Well, kind of multiple thoughts in regards to the whole thing. Sorry about the side of the highway. With you having that stance or that opinion, I don't believe that we're on the same page to be able to actually truly defend things. In regards to a video, I understand that part, but I also understand the fact that Scott Staub is willing to testify. There's no way at all that I should even have been legally charged with trespass, because there was nothing followed through with, even as of today, in regards to just the stipulated agreement between the attorneys for a payment. That's what the stipulated agreement was, because that's where the judgment comes in and all the stuff that's said on the stipulated agreement. In regards to the theft, that is something that the jail or the judge or would have to find out in regards to that. But if the same aspect of me being able to legally live there and still being a resident there, that also throws it up. In regards to the video, with the quotations of my truck, my stereo, I can prove that the truck was registered to my name. In regards to the burglary, in regards to the burglary, there's fine words that come into certain things, and beyond the reasonable doubt, the fact is that I didn't have no intent at all to steal anything. So that means that there's no chance of burglary, because you have to enter the dwelling with the intent. Yes. Okay. And if she did that, if she could do that, she did that legally under the civil compromise, because there's certain things that I understand, and I'm not upset. I'm talking. Okay. Okay. Or did I have any intent to steal anything to cause a burglary one? Because I didn't have no weapons, I didn't have anything like that, and I didn't go there with the intent to steal anything. And you have to have the intent of entering the dwelling. As they said, over 24 hours before. And then also, the other thing that's being looked over is the fact that, one, the video of me being arrested in December, that the officer brings up on his own free will right at the very beginning when he's arresting me. He mentions me being arrested in December. What caused it to go from them arresting me, reading me my rights, and then told me, them telling me that they're sorry, and then it's a civil issue? Yes, it is. Yes, it is. Yes, it is. Because how can it go from a civil issue to a criminal? Yes, it is. Sorry. Yeah. I'm not trying to disrespect. My anxiety's kicking in. I'm not yelling at you. Now you're going to yell at me. Like,
you're talking over me. You're not listening. You're being completely disrespectful.
Okay.
This is not a way a professional and a client have a relationship. So stop right there. And we're going to get on the right foot, okay? Talk to me about what you want in a direct manner, and I'm going to keep this very focused, because what we have is you charged with a burglary, where you go into a dwelling and take a stereo.
With the intent.
We know you have
stereo. With the intent.
There's no intent. Look,
you have, but for a burglary, don't you have to have the entering with the intent? And it goes into the cases that actually says that if you were over at somebody's house for a barbecue, and then they didn't plan on...
I hear what you're saying, and I'm going to explain it to you, okay? But here's the thing. Here is the thing. My legal explanation, it is the law, whether you agree with me or not. And you can get the opinion of another attorney, because I know because I spoke with Tim about this, that he's given you this exact same opinion, and I reviewed everything, and I agree. Okay? So this is your second opinion from the second lawyer that says the same thing. Okay? You are charged with a burglary 1.
Yes.
I have all of your other stuff in front of it. That on or about November 12th of 2021 in Jefferson County, you did unlawfully and knowingly enter and remain in a dwelling located at you know where, with the intent to commit a crime therein.
Yes.
You know, listen. Don't talk over me about. Listen. With the intent to commit a crime therein. They know you committed a crime therein because you have the stereo. You cannot argue that there was no intent to commit the crime if you have the consequence of the crime being a theft here. You are alleged to have taken a stereo. You cannot say you did not have the intent to go in there and take the stereo if you walked out of there with the stereo.
Okay. But
that,
last time we talked, did you not tell me what your job was to do, is to make sure the DA did their job correctly?
Yeah. I've gone over
so with that being said, even me agreeing with what you're saying, obviously it's not coming out to where it's translated to where I'm agreeing with what you say. But in regards to the fact of you making it to where your facts, you're making it to that's how it is. You have not been able to hear me in regards to certain things. Even last time we talked, well, then who stole the stereo? It was okay. There's over 24 hours of the stereo even being alleged where he left it on an outside porch, with a house that had no power, with a house that shouldn't.
So then where was it? Where was it when you got it? What are you going to get up on the witness stand and say?
And that is the fact of the crime. And that's what No,
because listen,
I know, I'm agreeing with what you're saying.
You take the stand and say that you didn't take it in that dwelling.
I don't have to take a stand.
So where is
I don't have to take a stand, sir. I don't.
Well,
I don't.
You don't, but listen. But listen, here's what's going to happen. They're going to get up there. He's going to get up there. Everyone's going to get up there. Because the police are going to read from their police report.
Yep, and then the officer should get asked if he validated a trespassing.
Listen, I'm not done. Listen, because you're not hearing me.
Okay,
I'm explaining this to you. They're all going to get up there and say, here's where the stereo was. It was in this enclosure on top of the refrigerator. The property owner's going to get up there and hammer it down. This stereo was on top of a refrigerator in a dwelling, in an enclosure.
Okay, and in regards to what you mean as a property owner.
Don't say anything.
Okay, but I can't ask that because maybe the definition of that is meaningful, and it does.
Listen,
okay.
You're not hearing me because you're focusing on what you want to hear and the consequences you want to deal with. You got to deal with the law and really the truth of the matter here. If you don't take the stand, option A, everyone hears, whether it's the jury or the judge or just all of them together, that the stereo was in this enclosure and it was taken. Okay? You don't take the stand, you're gonna get convicted.
I don't.
If you do take the stand and you give them an alibi thing, where maybe the stereo is somewhere else and we can credibly support that, then we change your burglary into a theft. But either way, we ultimately know that you had the stereo. So what I'm saying is, there's no way you can argue some of the things don't apply, like the theft, because you ultimately, the things that you're charged with, count 3, theft in the second degree for taking the stereo, we know that happened. The counts 2 and 3 are what make count 1.
We know that happened. We know that happened, correct? That's what you're saying. And I would like to be able to be heard instead of I'm listening to you and I don't know what else you need to say. You're repeating the same thing in just a different manner.
Okay, but give me your story again in a way. Okay. But how does it not fit
the story is this is America. Bottom line, you have to do things criminally and civilly and separate them. In regards to me bringing up the fact that in December, the Jefferson County Sheriff's Department arrested me read me my rights, put me in the back of his patrol car, then on record, as Enrique was there causing a scene, they acted apparently before they even validated that there was a warrant. That being said, they apologized and told me it was a civil issue. From December to January, that was still a civil issue somehow, but somehow it's transferred. At the very beginning, when the officer approaches me, he volunteers that information. In a trial, that's pertinent. That is very, very relevant. So that also brings in the jury.
We should do is to give a fact trial to a judge.
I don't know what that means. Like, I don't like.
Because so what you're telling me, all of these things are legal, right? Like
yes, I did not.
Issues, right?
How can I steal something from a residence that I'm still at? That's another legal thing.
Okay, but listen.
I am listening.
I'm not cutting you off. I'm trying to direct you here, okay, man? Chill out. Okay, that's a legal issue. Yes is the answer. Not keep running with it. Just answer yes. That is not stuff that a jury easily wraps his head around. That's why you would want a bench trial to a judge. So a judge who can assess and has experience with law can hear your legal issues and your legal argument that you're obviously going to say when you take the stand or whatever. If you want to say these things, the judge needs to hear them. That's why it would be better to have a judge trial than a jury trial.
Okay, and I also understand that, and I don't know if you've actually taken the time and looked at the whole report that I have for the discovery or whatever, but do you know how many acquitted charges or not guilty charges I have? You know that the DA right now is not doing his job by presenting that I'm more of a criminal than what I am because he doesn't want to take the time and actually look into things. And my anxiety is off the hook. I'm not yelling at you. I am literally rocking right now. I have been listening, and I've been very patient listening.
This is a Class A felony.
I understand that, but even you went into a civil issue that you said that you don't even really do. You do more of the criminal things. You said that. So with that being said, I'm also listening and hearing you say that. So here it is. I have my... See, will you listen? Because you keep stopping and interrupting me, and I don't understand how come I cannot speak. If Scott Staub is willing to testify in court, in the civil part, in regards to the landlord-tenant residency or non-residency, which would cause... What's he going to say? He's going to make it very clear.
Yeah, what's he going to say?
I gave you his phone number. Couldn't you take the time and find out? Because if the DA is doing his job, that's the important part for you, right? So the officer, he validated that I was evicted by Louis Morales. Louis Morales is not Gabriel Morales. Gabriel Morales is the one that owns the home. Yeah, you guys don't get it. You guys aren't listening. Bottom line, I got evicted after 4 years of doing everything right. Everything. And then turned around.
Wait, you just made one point and I need to talk to you about it, okay? You just can't hammer the stuff down without... So, you're talking Enrique versus what's the other guy?
Okay, so Gabriel Morales is the one that owns the property at 47 Southeast D Lane. Okay?
Okay.
Louis Morales is Gabriel Morales' son. Okay? Louis Morales was our property management or whatever. We paid the money to him. In regards to what was said under oath and testified, that home was either supposed to be destroyed or there was nobody even having the ability to move in or be in that place because it was already uninhabitable.
Stop yelling. Stop yelling.
I'm not yelling. Okay. I'm trying to breathe.
Sir,
and also...
I'm sitting right next to him. He's not yelling. I'm his wife and I've been with him for 9 years. This is not yelling. He's very animated.
I'm trying to slow my thoughts down enough to let you...
charged with felonies that carry a maximum penalty.
I understand, and I heard you say that before, sir. But I also heard you say that I entered the dwelling with the intent. And no hard feelings or whatever. But yeah, you're correct. These we have to figure something out in regards to my aspect, okay? Now, in regards to your power as an attorney and the things that you really truly want to do, that's all up to you. I can't make you do anything. But one thing I do know is that if you truly feel the way that you do, and if you honestly can tell the judge, if I need to, I will ask for whatever for another attorney. Because this is not okay.
Then fine. Then fine.
Okay.
I'm not gonna fight.
So, in regards to that, sir, in regards to that, are you willing to file a motion of dismissal due to the 4th and the 16th Amendment? Hello?
Like that. What are you talking, commerce?
What? The what?
Is this your case? Is that what you're asking?
I don't know. You broke up.
Is that what you were asking? For
What?
me to file a motion to dismiss your case?
No, I just asked you if there's a way that you could file a motion to the courts to have the case dismissed due to the Fourth and the 16th Amendment.
Your case is not subject to dismissal.
Oh, it's not.
These charges are very real.
Okay, I know they're real. I get that and I hear that, but so you're saying that you don't have no acknowledgement of what the 4th or the 16th Amendment is?
I have them all in here. I'm saying those do not allow the dismissal of your case.
Okay.
Let me grab it and I will quote from it right in front
So
of me.
you probably talked about a speedy trial.
Okay, so you tell me what under those
to educate
for
people.
your understanding allows you to get your case dismissed.
Okay, well, which aspect would you like to go? And see, this is the thing that people don't understand.
No, you tell me.
Okay, it's probably commonly referred to as a fast and speedy trial. It's also, there's another aspect that comes into total play or total reality of things.
Violation here, you're out of custody, and that does not attach.
Yes, it does. In Oregon, under House Bill 2358, I believe it is, just off the top of my head, that it is very, very, like, okay, this is where we're going to end up, but this is where, like, I don't want to start butting heads because I'm taking it as if I'm asking you things under the assumption that, okay, first off, I've never graduated high school. I know more legal crap because I have to what? I have to do the steps to protect myself to actually research or find out what it is that the rules apply to.
You need to be really careful about what you read on the internet. That stuff is like, it's all hocus pocus if you haven't actually got the
I know, and I'm hearing that very clearly.
And that's why it gets confusing. But every one of my clients that tries to Google things about their case and random legal things apply. Google will not tell you the law. You need to listen to a lawyer. I know what Tim told you. I know that I am.
You know what Tim told me.
I know that you're charged with a very serious crime, and that legally you're not hearing that because you took the property. The fact that you have the property.
And see, that is the aspect.
The language of a theft here is that you knowingly commit theft of stereo. That is count 3. That's just the theft.
Okay.
We know you have intent, knowledge. You have knowledge to commit the theft because you have the property of the theft. And when we apply that to the burglary, it makes a burglary. You have the stereo. That's terrible for your case. We can do a stipulated facts trial to a judge, but the things you're talking about, your speedy trial rights are, in this case, it's 5 years. Well, actually,
no, that's actually to be charged with a crime. Felony. That's to be charged with a crime. Like they have that much.
You're charged with 3. You were indicted by a grand jury.
I understand that, sir. And I also understood from what my understanding that most Americans even believe in is the right to counsel, the right to defense, the right to a trial represented by your peers if you choose to or whatever. I am just now being informed that apparently my whole time that I've ever dealt with a lawyer in a defense case, I've been tricked or I've been somehow misled to where it's not about the defendant being able to be proven in court that they did not, beyond a reasonable doubt, do such and such. You have informed me that the defense lawyer's aspect is to make sure the DA does their job right. When I'm telling you that even as of right now, you've already admitted that the stipulated agreement, that was the eviction. You are incorrect about that. That is not true. So the trespass, which means if there was a theft, how could I steal something inside my own residence? Okay, if that is alleged, okay? If there were a burglary, you have to enter.
because we went over the
Okay, then would you like to prove to me, if you haven't taken the time to call Scott Staub, and you already said that you don't do civil issue, and the cops already arrested me and then let me go and apologize because they said it was a civil issue, and I've already provided you the information to have him subpoenaed or for you to even talk to him. You are standing on your stance and your opinion that is which is making miscommunication.
Stop if you want, but I've already gone. You and I went over it together. Here's the stipulated agreement
between two lawyers. Between two lawyers. Between two lawyers. For the money that was already paid.
Listen.
Yeah.
Stop talking.
Okay.
Okay. Stop talking over me. That you agree to vacate the premises and remove all property no later than 11:59 on 10/31/21. It was signed by Judge Vidalin on 7/26/21.
Yeah.
It was signed into law by a judge as a binding order.
This is about the first attorney that you had.
What am I supposed to reply to that?
That alone makes it a trespass.
That alone does not. Because you saying something does not make it law, sir. Just because of the way that you interpret something, that doesn't mean that that's law. If you have to go through life thinking that you know everything, you'll never be able to learn something. You always have to look at your glass half full, not empty. So
you need to listen to your own advice here because you are not listening.
No, I have listened.
To the second legal opinion.
No, because why? You tell me that you know what he said to me. There was already, and when I first talked to you, you said, "Oh, this is already resolved." That's what he told me. That's what Gassner told me. No, like you went off of whatever it was that you were already told, and you didn't even give me a chance from the beginning.
Mr. Talbot, then what about your case do you think we're going to prove to the judge beyond the or they're not going to prove? How are we going to defend your case at trial? What do you want me to do at trial?
Well, first thing is to get a defense counsel that is actually there to defend the defendant, not actually cover the DA's job or what the DA's actions are, because it has nothing to do with a personal thing between the DA and the defense.
Are you firing?
No, I asked you first. I know where you're going with this, and I have to be very clear. I asked you if you could file a motion to the courts to ask for a dismissal under violations of such and such terms. If you want me to break it down to you on which terms we can. But in regards to just which aspect. Okay, the 4th, the 16th Amendment, fast and speedy trial, whether you think it is or not, House Bill 2385 or 2583, that passed in 2021, there's a House Bill, meaning a state. It would apply to the case because it's a state order from the legislature that is put in place, just like House Bill 3511, which comes to the homelessness and being able to have rights to certain things. In regards to...
Listen.
I'm listening. And every time I go to tell you something, you interrupt me and you tell me to listen.
You're not listening to him, sir. You're being
I'm not
really
filing an unethical motion.
Professional code of conduct,
You tell me to. You don't even understand the law that you're talking to me about your speedy rights to trial that has not been violated in this case.
90 days from the time of arraignment. Correct?
That is absolutely untrue like that.
Okay, but is it not 90 days from the time that you were arraigned? If you're out of custody, you have 90 days. Due to the overwhelming, due to the overwhelming caseload, the defense...
No, that's not the law. Your understanding of the law is incorrect.
Okay. Okay, that's what... Yeah.
You are wrong.
Okay,
You have a right to trial at the fastest 5 years because of the C-level felony. Or actually, no. If you want 2 years to speedy trial because of the A misdemeanor theft in the second degree because you're out of custody. You have a 60-day right to a speedy trial when you're in custody. That has been doubled and extended due to coronavirus to 120 days. If you are, again, in custody for a straight 120 days.
And in regards to
your current application of your speedy trial right.
And in regards to the downward departure, you were informing me that 30 days or whatever for downward departure. If you actually look at the aspect of the sentencing grid and how it falls in, the A whatever it is qualifies for such and such or whatever, and that has to be like looked at. And I don't.
You're 7A. You're 7A because of your criminal history.
And that's changed how many times? How many times has that changed in my cases? Do you know that, sir? Just over these. Do you know like how many times they told me?
What?
Okay, in regards to when I got arrested.
It means you go to prison for 3 years.
Okay, what it means is I'm asking you a question. How is it, or do you know how many times, from the time I was arrested, on how many times I was told by a legal professional that my grid, letters and numbers, were such and such? Do you know how many times that's changed?
I do not care.
Okay, you don't care, but yet, do you realize that when I was first charged with the crimes, there was the DA that was a female? Okay, then
it does not matter.
Oh, it does matter because of the fact that there's certain things that go into that aspect.
Mr. Talley, you are not a lawyer. You do not have experience in court. You do not understand how these things work. You have no place to tell me how it should be because you do not understand.
I'm not trying to tell you how it should be.
You need to stop assuming that you know how court.
You're right, and I should have not assumed that a defense counsel was there for a defense, like to defend the defender.
My opinion has not changed. I will go to trial for you, and you can do whatever you want to do. But based upon everything you've told me, especially coupled with the YouTube video of you having the stereo, the fact that you have the stereo, the fact that your girlfriend sent text messages begging to return the stereo in exchange for everyone dropping the charges, I do not believe you can prevail at trial.
I don't believe that that's what she said.
You can do whatever you want.
I don't believe that that's what she said, though. I believe that she actually asked to return. Okay, and maybe your interpretation of what she said, as far as I understood, it had to do with returning the stereo to him.
I will read them to you. My God. Like, if you don't believe me and you think everything is a conspiracy,
I'm not saying that. I'm not saying that at all.
You're going to suffer these horrible consequences for the rest of your life.
Yeah, and you think it's kind of comical, huh? But you know what? The sad part is that you have sat here and told me that you're wrong. But yet, I'm even acknowledging that I'm listening to you. I'm even doing my DBT skills the best that I can to be able to ground myself, to be able to have a conversation that's productive. Because it seems so hard to be able to communicate with you and actually go forward rather than being placed back or going over the same thing. That's where the abuse starts coming in. So, in regards to... Okay, see? You go ahead and read it. Go ahead and read it.
Are you ready to hear? Is there any way that we can come to a civil agreement where we return the stereo to you and drop the charges and all this can be over with please and thank you? This is, I can bring it to Madras tomorrow. The attorneys refuse to let us give it back to you, even though we know that it belongs to you now. So that is why I'm reaching out to you personally.
And what is wrong with that, sir? Is there anything wrong with that?
That wasn't you that said that either.
That wasn't me that said that.
You have the stereo.
That wasn't me that said that, though.
That you guys want to give it back in exchange for the dropping of charges, and this is just literally what was said.
Okay, and even if that was...
literally backfilled the case
that wasn't
that
him,
you took a stereo that wasn't yours, that you committed theft of property.
Okay, that's where...
Like, from two together, so since we know you have the property, you're trying to give it back. We knew you had to be there at that location to take this stereo, this piece of property. It just backfills the whole case.
Okay.
Basically, it's admitting that you did it.
It's not his number.
But you know, it's like that one movie or whatever, and I know it's not about a movie, but at this point, it's not becoming productive or anything positive in regards to you just overhashing things when obviously you don't have the ability to represent me in a way that is going to be legal. Because like I said, I've listened to you, and even to the fact of you telling me that your job as a defense is to make sure the DA is doing their job right. In regards to how this is going in a circle and me not trying to, I don't know how to change it to where our communication can be any better. I've tried very...
Would you like to try a third attorney?
Sir, you are my third attorney, but technically you're my first attorney. So yeah, I am ready if I need to, but in this, the fact of how much trauma, and I'm telling you right now, and you should listen, because you know what it is this causes trauma. This causes trauma. And you guys get a kick out of it. Why? How?
One of you guys have left, Tad.
You guys have all the letters. You are one of them guys. Because you're telling me that you're the only lawyer that will say that they have to make sure that the DA does their job right. I thought that's the judge's job. I thought that's what, like the point of a judge.
It's all of our jobs to make sure that the law is applied correctly, that a just sentence is imposed, and that everything is done the way it's supposed to be.
So with that being
there's
said,
a way for me to suppress the evidence in your case and hide that, suppress statements, suppress something, to make it so the judge, the jury, anyone at trial didn't know these things, I would. I can't.
Okay, but what's the problem with having the video from December when they arrested me? Why is that being such a hard thing to even request? Or why is it that I have to explain why that's relevant when the cop approaches me and mentions it right off the bat? That is very relevant, because why even to the judge and on top of...
So there's a hierarchy, right? Cops write police reports, they send them to DA.
Yeah, and the cop testified in the grand jury. The officer testified in grand jury that he verified that I was trespassed. He verified only by word of mouth from Louis Morales. Do you understand that? So because the officers testified of me being trespassed because I was evicted.
All he has to do is look on the line for the judgment that orders you evicted, and that constitutes verifying your trespass?
I don't understand what you're saying with that. In regards to the stipulated agreement they are referring to, that is a stipulated agreement between the two parties. Whose names are on that document, sir? Is it mine? No, it's the two lawyers. It's Scott Staub and it's their lawyer that they had. Okay, that being said, I don't have the energy, nor should I be this worked up in regards to having to it feels like a battle to explain to you that even the lawyer himself is willing to travel down and testify in court because there was no eviction. And what Louis Morales, the property owner, is what's being said in the criminal aspect, okay, is alleging that I was evicted and had an order of eviction. That was never verified at all from the sheriff's department other than what Louis told him. There's still no eviction.
But hear me out here, because whatever. Even if Mr. Staub testifies there was no eviction, in public court documents, in the case file, online, publicly accessible for anyone, there is this stipulated, signed judgment saying that you agree to vacate.
No, there was a signed judgment with the two lawyers in regards to what they agreed to, what their understanding was, and what they would agree to. If that did not get met, there were certain things that had to go through, I guess. But in regards to that stipulated agreement, you can verify right now with your own eyes that is Scott Staub's signature and that lawyer's signature. That also goes into detail about how money should be paid and by when the money should be paid, because it's a stipulated agreement between the two lawyers. Bottom line, the lawyer was paid by their party to only show up and try to get that. Then they didn't pay the lawyer. So what'd that do? That left the ball in their hands that they didn't end up paying the lawyer, and they had to get all this stuff. On top of the fact that the agreement,
Wait, you made a point, and I got to give you a counterpoint, okay? Those are separate things in the stipulated agreement. Number one is that you agree to vacate. Number two is the payment of fees. And at the end, there is the ability for either party to file an affidavit of noncompliance to enforce those
exactly.
1, 2, 3s.
Exactly. And my property was thrown away in the garbage, which meant that my stuff was not out of there, which meant that they should have filed the stuff that they didn't. I'm agreeing with you. But you're just not hearing me say that. I've been saying that. They had to file an injunction.
Listen, it means... No, you're interpreting it wrong.
No, because Scott Staub's willing and ready, and he's the one that told me, and I have faith in regards to his record and how many cases he actually does with state and federal evictions.
And
so,
listen though. So, an affidavit of noncompliance that you're talking about to be filed with the court, what that is essentially kind of like a contempt to try to force a party to do the things that are enumerated in this judgment, 1, 2, and 3. 1 being removed, 2 being payment of fees, and 3 being any changes to this agreement shall be in writing and acknowledged by all parties. That means, what it means is that it is civilly enforceable by this affidavit of noncompliance, which again is like a contempt, to enforce those 1, 2, 3s.
You're wrong.
If a party
You're wrong. You're wrong. You are wrong.
You are assumed to have do them. So 1 and 2 are separate. You leaving and removing your property is separate from the payment of fees, and if you did not do those, then the person who is aggrieved by you not doing them can file this affidavit of noncompliance. Because you left the property, and
did I leave the property? Did I leave the property?
Filed against you.
Did I leave the property?
One,
did I leave the property?
The fees is separate.
So did I leave the property?
It's separate.
Did I leave the property?
You were ordered to, yeah.
Did I leave the, no, I'm asking you. Did I leave the property?
By all accounts, from what you've told me and everything else, is, well, yeah, you were kind of in transition, I guess.
Transition, meaning I did not actually leave. Okay, keep in mind that they illegally, yeah, and I don't have to battle this stuff with you, but bottom line, you're wrong in regards to your understanding of that aspect. And in regards to what I've done to legally take care of a civil agreement or a civil litigation that is still going in process, that this criminal aspect does have an aspect to it. And what is currently going on is there's two hands in it. You don't need to be able to be in that part because all it does is just twist shit up more. And I know that I shouldn't have to sit here and, what do you mean what I want? I would like for you to actually take a couple deep breaths or something. Maybe I don't want you to take home, you know, work to home or whatever.
Sir, you're yelling at me?
No, I'm not.
Sir, you're yelling at me? You need to stop and don't tell me what to do, okay?
Okay, first off, I sat here and I've yelled at you just like I am now, and then you don't say nothing. I can calm down and I can talk, and you tell me that I'm yelling.
Calm down.
Yeah, calm down. Yeah, I just did.
What do you want me to do? I've told you my legal analysis. You don't agree with it. What would you like us to do on your case moving forward?
I would like, I don't know what aspect of certain things because I don't know how to research into those possibilities of whatever it could be. I just research what it is that I know that I have to deal with. And what I know that how it is in regards to somebody, which was not me, contacting Enrique about a civil litigation or a civil agreement, compromise, is nothing illegal for a criminal aspect. You informed me that that was not possible. In regards to a civil compromise, under the crimes and or the injuries of the level of the felonies or misdemeanor,
Breaking up and I can't hear you.
the certain aspects of what it takes or not takes to do a civil compromise or a civil agreement to get the criminal aspect, because it's in the criminal section where you can actually find the civil compromise. There's certain things that get wrote down.
Okay, wait. You wanna ask for a civil compromise? That's fine. I'll go ask. I'm telling you though, if they have made it clear to the channels of the DA's office, 1, they don't want it, and 2, even if they do agree to, DA's office does not agree to it.
Okay.
We go to a hearing in front of a judge where the judges here, in my experience, have always sided with the DA's office and do not agree to civil compromises of Class A felonies. Okay?
They typically don't, yes. I can agree with that.
How much do you get paid?
No, I've never seen them.
How much do
Okay. Well, just because you can't see the wind, you can feel it, so it's still there. You know what I'm saying? Like, just because yeah.
Yeah, okay. So I'll try civil compromise. What if it's civil compromise not work? Then what?
Okay, well, in regards to the civil compromise part, I'm looking at that just for what it is, okay? And I understand that you've told your aspect of how you and like how you think things were or whatever. But in regards to you even asking me or anything like that,
Mr. Talley, you've been yelling at me for a solid 40 minutes.
No, I haven't. I'm talking to you right now.
With me and tell me what you want.
I am getting there, and I want to articulate with you very clearly, so that way there's no miscommunication in regards to what the civil compromise or civil comes to.
Do it.
Okay, and I'm trying to, and you keep interrupting me, telling me that I'm yelling at you or whatever. And it's very frustrating. So what I'm saying is that we're willing to give the stereo back. Okay? The stereo going back only shows that what? We know that it's his. Okay? That being said, in regards to something that is in my residency that I'm legally still able to go to, regard the trespass, regard the burglary, okay? In regards to just the theft of Enrique being the victim, there was no intent to even steal the stereo. There wasn't like, there was like, I don't know.
I hear that. You've said that a million times. Okay, so we can try a civil compromise, and then do you want to do a stipulated facts trial to a judge where we argue you didn't have the intent to take the stereo?
I don't know what you mean by with the judge part, because that's not what I understand. A civil compromise is usually when the lawyer reaches out to the victim and basically explains to him.
Mr. Talley?
What?
Yeah, I know exactly what
Okay. Does that offend you that I'm trying to articulate with you my acknowledgement or my understanding of the thing? You have to be rude and you have to interrupt me and say, Mr. Talley.
You're telling me how to do my job.
I'm not telling you how to do your job. I'm actually communicating with you so you can understand my understanding of interpretation.
Stop yelling at me.
Okay.
Stop yelling at me.
Okay. You know what? You need to stop saying
You are so out of line. You want me to do a civil compromise. That means I go talk to them and ask them if they'll do it. I have investigators to do that. I will do that. You do not need to tell me how it's done. I've been doing it.
Well, you just mentioned something about the judge.
If that does not
So do you understand why I'm not understanding that? Because you mentioned something about the judge. So that got me confused. That's why I said something. And then it went into the circle. Because I didn't understand the aspect.
I'm going to try to do a civil compromise, and then we'll go from there. Okay?
But what did you mean about the judge part? Is that part of the compromise or not?
No, that's completely separate. What I'm telling you is, I know because I have asked this DA. He will not agree to a civil compromise. That means even if this victim agrees to a civil compromise, no matter what you do or what he asks you to pay, because let me tell you, a civil compromise isn't just you giving the stereo back. They are aggrieved and they have leverage over you. If I was this victim, and in every situation like this, the victims usually ask for a lot of money to come with it. That way they'll sign a document for them to drop the charges against you, because they know that a civil compromise drops the charges against you, and they know that these charges can put you in prison for 3 years because the DA has sat down and told them. So you can try that, and if it doesn't work, then we can talk about a trial. If you want to do a trial, because you talk about all these legal issues, I do not believe a jury would be able to understand the way you want them to. And that a judge trial, so you can say your legal issues to the judge, would be better for you, so the judge would be better equipped to understand your legal issues.
Okay, and then in regards to that victim, and even relativity or whatever the technical word is for witness or whatever for court, that video from December becomes very, very relative and becomes very to the point to where I'm looking at the body cameras and I'm very clearly telling the Jefferson County Sheriff's Department if this is how they act by getting a call from somebody like that, to have them put me in cuffs and then apologize and tell me it's a civil issue. I want this harassment to stop right now. And that, it was straight to the body camera, because I know that camera. Because why? My mental health allows me to be able to do what's DBT skills, which is doing videos. They never turned into videos for entertainment. They were videos for my mental health.
How does that prove a FACTA issue? And the FACTA issue is whether you went and you took the stereo, more or less likely in this case.
Okay.
Because that's the legal definition of legal relevance. For what
and in regards to legal
I do not believe it.
In regards to legal aspects of even residency or what, and I understand you don't want to hear the legal part.
Relevant.
But it is very relevant if I am the tenant and I'm still have the legal right to be in that house. And why would his property be in my house? So it's not about what you know, it's what you can prove. And there was no intent at all, and this is where it gets all mixed, because it starts getting into the other charges.
No, but listen, stop for a second. You have two competing ideas. Put both of those to the judge. It hangs you, okay? That's like a Dewey trial for a person to say, one, I didn't drive, and then they're trying to say, well, I drove, but I didn't drink that much. What you're saying is, one, you know, I wasn't trespassed and I could be there. And the other one is, well, you know, I took the stuff, but, you know, it was somewhere else.
No, but you see, why would I have to admit to taking it? Why would I have to admit to taking it when I can just admit to what the video says? Even the last court hearing that we had, the DA himself says that he hasn't had time to even watch the video. So in regards to how he thinks that he has a stance in trial...
So would you take the stand or would you not take the stand in your...
I will figure that in the future. Like, that doesn't have to be determined right now. But in regards to the certain aspects of the case, that's where it gets very, very detailed and becomes very relevant to a criminal case, because even yet alone, from October 31st and our property still being there on November 12th...
Wait. All those videos, all that stuff that you would even hope to get in, the only way it could ever get in is if you took the stand, because you would have to explain all of these.
So then how do they even know I have a stereo then?
At me about right now?
If the video is all that they have and they can't even use that unless I actually take the stand. In regards to charging me criminally, how can they even be charging me with it if they can't use that in trial? Because it's the DA's job that when you charge somebody in an arraignment, they're supposed to be ready for trial at that point. In regards to the video of December...
Mr. Talley, don't go off about what the law is, because you were talking to a lawyer who knows. You don't, and you need to stop.
Okay, so I'm not trying to. I'm explaining to you.
That's why you were getting confused.
No, I'm not. No, then, and very clearly, how can we and will you get the recording from December and get that prepared for trial?
I can ask.
I can have it. It's very relevant, and I don't.
The police department, and you ask me a question, I'm answering.
Okay.
So wait and listen.
Okay.
I'll have for all the things that you want. I don't do them. An investigator does. The civil compromise, as well as trying to collect your video. If they can, it would be to a public records request. If a report was generated, and if that in captivity storage somewhere. If it is not, if it wasn't stored, if the report wasn't generated, never be found.
It was there. It was there with the day I got out of jail. It was verified by the sheriff's department, but the thing isn't on how much money that has to be paid for the video, because we requested it ourselves, because they actually have to go through the video and delete everybody's face that was there on that whole video in a public place.
Do you have a copy of it then?
What?
Do you have a copy? You said you requested it. Do you have a copy of it?
No, I do not. Because they have to go through the video from the time frame of when the camera started. Then they have to turn around and each blur face or blur whatever, or even a business. All of those things have to be blurred out of the video, which changes the price of that, because it's going to a public record by the time we get it. We're not using it for evidence in a court. We are getting it because why? It needs to be public.
You don't need to go off about all this.
Well, I do, because it's and that is connected with the civil litigation.
And that's how we get through this conversation. So you don't have the video. I can have an investigator try to get these things. We can try to do the civil compromise. We can try to get the video from December. What else would you like?
I guess I don't know what to say at this point. I'm not trying to take up your time. I don't know if we're even to the point where I'm comfortable to putting that into your hands, I guess, because you were very clearly.
No, fine. Are we back? And I'm going to ask you again. Do you want another lawyer?
I would like for you to be able to do those certain things first, because even from the first attorney, they were supposed to actually find out about.
No. You just went off at me for 45 minutes,
okay.
And now you're telling about everything you wanted and how you had to explain, and then you just said that you don't have faith in me to do that, and now you're about to go off on me again about this, that, or the other. You're going to answer me. You're going to answer.
Oh, I'm going to answer you, right? You're not going to tell me what to fucking do. You're not. You have been disrespectful. You've been demanding. You fucking raised your voice at me.
No.
Yeah.
It doesn't have to be professional.
Yeah, I'm not the pretty. Yeah, no.
So
I think that it's time.
We are done. We are done.
Yeah. Okay. So what does that mean in your aspect? Because when I hear that, that means that you're going to withdraw. And yet again,
I am withdrawing from your case. I am not taking this abuse from you.
And yet again,
you will not yell at me. You will not yell at my assistant.
I'm not yelling. What assistants have I talked to? I've never talked to your assistant.
We are done.
I've never talked to your assistant. Do you know that?
You have scheduled appointments with her.
No, she called today to have me schedule an appointment with you. You answered the phone and you wanted to do this now. There was no communication. It was on my voicemail. Do you understand that?
You need to stop. You need to stop and let's all be adults here.
Yeah.
we're done. You obviously can't work with me. You hate me is what it sounds like.
No, because it's not, that's not true.
Opinion.
It's just because of the fact I ask questions and you don't answer them. In regards to even you accusing me of yelling at your assistant. That's a fabricated, that's totally fabricated. I've never, they called today. Yes, they called today. They called today, sir, and left a voicemail. Because
you're yelling at me right now.
I'm not.
And you haven't stopped for 45 minutes.
Okay, whatever. Whatever, dude. I'm recording this and I don't care what you want. Like, no, like this is my life. Why? Because why? Because everybody rather.
I hope you did record this.
I hope
You have been so disrespectful.
No, sir, I'm going to stop you right there because that's not
line this entire conversation.
No, that's not true. I've very even articulated with you in regards to how I'm trying to calm my mind, my rapid thoughts, and to where they come out correctly to get you to even hear me agree with you. You've gotten to you were at the point to where I was agreeing with you, but I was still, stop, Mr. Talley, stop. And in regards to like certain things that is relevant even as a human being.
Now you're yelling at me.
No, I'm not yelling at you. I'm not.
You just did again.
Okay.
Lower your voice then.
Okay, then you know what, sir? Where do we go from here? Because at this point, I'm not going to take this abuse. And this is what it is, it's abuse. Because you sat here and you tell me that I'm yelling at you when I even speak calmer and even ground myself to be able to get that clearly out and only to be accused of something that's not true. And you can even go back to this 40-some minute conversation and you can see how my voice goes from yelling to where all of it. So,
I'll get you a new lawyer because you obviously
so you're
cannot work with me.
You're gonna do that on your request then?
Okay.
Is that what you're doing? You're gonna do this on your own request, just like the last two lawyers?
You just fired me?
No, I did not, Mr. Nelson. I did not, Mr. Nelson. I did not fire you. I was actually still trying to work with you, and you said, I'm done. That's how it went. Which is exactly how, and apparently I can't bring up...
So here's what I'm saying. Here's what I'm saying to you, Mr. Talley. You have told me that you do not have faith in me. You have told me that you do not believe in my analysis of the law. You believe that I am inept and unable to do my job correctly.
Which your job is to
file motions to dismiss your case.
What's your job is to make sure the DA is doing his job, correct?
I have heard you for 45 minutes yelling at me, cursing at me about all of these inefficiencies and deficiencies of me as your lawyer and how I'm not living up to your standards. That is the most long-winded, abusive rant I have taken about how I am not the lawyer for you. And it's okay. You could have saved us all a lot of emotional trauma if you just said, hey, I don't want to work with you anymore. But we're here, and it's fine. And we're going to make sure that you find someone that you can work with.
Yeah, and I also don't... I would like...
If I am your third one, maybe the judge won't allow us...
Yeah, that's what you're probably hoping, huh? But yet, here it is. You accused me of yelling at your assistant, and I never even talked to them. And I'm trying to even tell you that they called today, left a voicemail, which caused me to call you. See, and you interrupt. You don't even want me to finish because you don't want it on the... You don't want... What?
Told me that you yell at her.
I did not yell at her. I've never even talked to her. I've never talked to her. She left a voicemail today.
You're yelling at me. How can I not believe her when you
Then believe what you want. Okay? Believe what you want. But I'm not going to say, if I do not defend those allegations, they become true and accurate, right? And I am defending those allegations because I've never talked to her.
How can I not believe that you're not yelling at my assistant?
Because I've never talked to her, and I got the voicemails to prove that she's called. Yeah. Whatever with your assistants. I'm telling you that I have the proof to show that she called not even an hour ago, or an hour and 15 minutes ago, and asked to set up an appointment with you. I called, you answered your business phone, and you wanted to handle this right now.
Okay, and that's fine, and I'm glad I did.
But you're making it look as if I'm trying this, like I pulled over on the side of the road, expecting to just make an appointment, and I even like am taking the time, just like you're taking the time, but I don't even get acknowledgement for that. I get accused of whatever else.
I just gave you an appointment on the fly. You should appreciate that.
And yes, and you should also understand that I called back. I called back, and you should be able to understand I called back because I got a voicemail left by your assistant saying that there needed to be an appointment set up.
That's great.
Even though I told you when I called you Tuesday.
These are things
I called you Tuesday and left a message, never heard from
Why
you.
are we even fighting? Why are you yelling at me about it?
I'm not yelling at you about
You got your appointment. It's good, right?
it. Okay, it's good, right?
So,
Yeah.
again, I'm done being disrespected by you.
I am too.
I really hope you did record this because this has been insightful for how you treat attorneys.
Okay. Yeah.
And I'm gonna make sure that you get another one. Mr. Talley, I wish you the best of luck, but there's no way we can work together
I know,
ethically because of all the things that you have said.
But also,
that
the
are
things
so
that
bad
you've said
about
in regards to
employees.
your job is to make sure the DA does their job. That's your job. I was just informed.
Goodbye, Mr.
And I hope that you tell the judge that
Goodbye,
part.
Mr. Talley.
Yeah. Okay.
Goodbye.
Goodbye.